was about the dogs. Nah, it's about power. Yeah. Put up to the specialty, sunrise on the ground. Dogs in the grooming tents, whispers all around. Catalog smiles with the tension in the air. Every handshake got a hidden little snare. Bored in the back room, running quiet little schemes. Bylaws in the pocket like a stack of poker dreams. Say it's for the breed, but they guarding their throne. If you question anything, they coming for your bone. Grievance in the envelope, certified mail. Club justice system, but the deck.
So I did it again. I didn't put myself in the thing. So good morning, welcome. If you're new here, welcome back. I have to do this whole intro over again because apparently I forgot to put myself in here like I did the other day. So apparently yesterday was kind of crazy. They ended the day with just ending it instead of coming back and doing anything. And I guess the defense is going to rest today, and then it will go to, they'll do a little bit of rebuttal probably tomorrow, and then I'm guessing that it will go to early next week, go to the jury, which I imagine with all the evidence and stuff that they have to go through, it will take a couple days maybe with the jury, unless they've already made up their mind on guilt or innocence. From everything that I'm seeing, it seems to be maybe a little bit more for Lindsay being not guilty. But even if she's found not guilty, she'll probably still have to go to stay in the mental institution for so many months, maybe even years, until she's deemed stable before she can go home. Is my understanding of how the case is going to work. So she doesn't get to go home. It's not like she found not guilty and she gets to walk out of court and go home. So So what did everybody think of the prosecutor? Boy, a lot of people have have an issue with the prosecution, the prosecutor with the bow, the wears the bow in the hair all the time. A lot of people have a problem with her. But what did you all think of the timeline of each of the deaths and the birthdays, the death anniversary and the birthdays of each of the children and how she was doing on each of those days? Some people felt that it felt flat. Other people felt that, you know, they've had loved ones or whatever that have died. And each year on those anniversaries or birthdays, it destroys them, so they can't understand how she doesn't have some kind of feeling towards those days. So I don't know. To me, I think it's very telling. A lot of people are still blaming Patrick for doing it, but I don't think he did it, as in he's guilty of doing, you know, committing the murders. My issue with him is that he just was not involved in his life, but a lot of pressures on her. The problem that I have is that even in her journal, she wanted to have another child. So she knew she had postpartum with the second child. She had a third child, you know, and then she went, even in her journals, wanted to have a fourth child. All that stuff, still having all these issues. Also, the psychiatrist yesterday speaking that she heard these voices. That got a little muddled, in my opinion, because she heard these voices but never told anybody, you know? And I understand the difference between she thought people could hear her own voices. That I get. But then she heard voices, right? But she never told anybody. Except the one pastor or minister. So did she hear just the one voice once? And if she heard voices since October and all this stuff going on, why did she never follow through with what those voices were telling? And why did she never tell no psychiatrist, no doctor, no anybody that she was having or hearing voices? I just have a problem with all these people that nobody like committed her. Like she told, so two people we know, her, you know, Patrick and her mother. Yeah. Is her mother? Yeah. It was either the mother-in-law or the mother, one of the two. Both knew she had thoughts of harming herself and the children. Both of them knew. Nobody did anything. I have a problem with that. Also, now we have from Zeizel, and it was really good on the one key point that the prosecutors made is that only one other patient that he's had, that he's evaluated, that he's done this much work with. I think that was a really good point. So he looks at her different. That's a biased opinion, and you can't deny that. It's a biased opinion. He may have empathy for her. He may like her. He may want to be trying to help her. but it is a biased opinion because out of all the people that he's treated, all the people he's done evaluations on, only one other person he's ever gone to this extent with. No matter how you slice it, you cannot like the answer, you can whatever, that's a biased opinion. You then start to slip into biases of her. So I think that was a really good point that the prosecutor made. I think there was good points on both yesterday. And I think it was weird too that he wanted to have fresh eyes, so he didn't look at any of the previous records of any of the other doctors and stuff like that and blah, blah, blah. But yet Reddington kept reading all the damn, having the other doctors read all the damn doctor's notes, and why didn't you call, why didn't you have her do a HIPAA release, do all this stuff so you could get notes from the other doctors, blah, blah, blah. So which is it? Do you need to have fresh eyes and start doing it? Or do you get opinions from the other doctors so you know your assessment? So for his psychiatrist, it was okay to have fresh eyes and start over. You see what I'm saying? Like, so I think that hurt him, because for the whole 3 weeks that we've been doing it, he's been hammering, you didn't do this, you didn't do that, you didn't do this, you didn't do that. And he kept reading other people, having each doctor read other people's notes. And kept saying, don't you think it's important? Don't you think it's important? But with his own psychiatrist that is assessing her and evaluating her and building a rapport with her, he's not going to. He wants fresh eyes, which is what the other doctors did. So he makes them look bad, but his psychiatrist isn't, for doing the same thing. So, there's key points in each of them yesterday. And he just doesn't seem, he seems to care about her a lot, that's for sure. But there's where, when you're an evaluator and a treating physician, it becomes very murky, and you can't have an unbiased opinion when you can have empathy, and you can have, you can feel for the person, but you can't have, and I think his relationship with Red calls into question his biasy. And the reason I say that is because if they're talking at night, they're going over stuff, they're doing all this stuff, and all Red has to say is, man, I really wish it would say this. I need it to be this. I really feel like it's this. Can skew somebody's opinion where he says, well, yeah, it could be that. Well, you think it could be that? Yeah, it really could. And as you're going over 60 some days, hours, whatever, it can start to lean that way, because 20 years of friendship, you want to help them out. That's why you need to bring somebody in that's not going to be your friend, and he's probably has great admiration and love and respect for Red. And not to say that he can't be unbiased because they're friends, but 20 years is a long time to have a friendship. It's no different if, you have a friend and they have a relationship, and that person, calls you up and says, well, I'm just having a really hard time with this person, and he's saying this or saying that, or he or she, whatever, saying this or saying that, whatever. And I just think they're being unreasonable, and you tell the situation to that person. their opinion is going to be skewed towards you because you have that relationship. And you're going to look at the person they're talking about in a more diminished light because, well, you want to be on the side of your friend. Most people can't separate the two because, well, you want to be on you want to be on the side of your friend and help them. It's human nature, it's human nature to be like, no, and you might even at the beginning not see it in the way of your friend. So you might try to help them out. You might try to give them a difference of opinion to help them see. But if they're constantly coming back to you and telling you the same thing, and oh, well, it's this and that, and they keep pushing that narrative to you, you are going to maybe start seeing it. It's again the whole thing of you feel fine today, and then you have a person say, huh, you okay? You look tired. And then you're like, no, I feel fine. And then you go down the street and the next person says that you meet that is your friend and you're talking to them and you're like, oh, you look really tired. You feeling okay? And you're like, no, I feel fine. And then maybe you go to the gas station and the person says, that you've talked to 100 different times, says, wow, you look really tired today. You doing all right? Now you start to feel tired, right? Because your psyche is starting to say, wow, maybe I do really, I kind of feel tired. It's the same kind of thing. Okay. We're in session. I'll probably go to sidebar.
Court is now in session. You may be seated.
Right?
Yes, please.
Now, the hearing for today, we have the matter of Commonwealth versus Lindsay Clancy. Ms. Clancy is present. She is represented by Attorney Kevin Reddington. And Commonwealth is represented by Assistant District Attorney Jennifer Sprague and Assistant District Attorney Sheila.
All right, well, good morning, everyone. Good morning, counsel. Good morning, Ms. Clancy. All right, before we get going, can I see counsel at sidebar?
He's so predictable. Sidebar. Can I see everybody at sidebar, please? Jeez. Oh, yesterday too, they wouldn't let the TikTok chick. He denied the TikTok chick that worked there because, like I was stating to you, I'm talking to you, Aaron, because I don't have anybody watching me right now. He denied the chick because, like I said, there was too big of a gap. So she wasn't bringing anything new. The staff could have changed. They could have changed rules from the time that she quit to the time that Clancy was in the hospital. Also, she worked 8 to 5 and she didn't work the holidays. She may have picked up shifts. She may have picked up holiday shifts, but McLean sent their hours, their schedule, all that stuff, and it differs from what she stated. So things could have changed because there was a lapse of time period of 1 year. So things could have changed and she wasn't going to add anything new. Although she was a credible witness from the time that she worked there, she wasn't going to add anything new, and things could have changed because she hadn't been back there and she wasn't in the ward or in the wing that Clancy was in, nor was she working the hours that Clancy was in there. And you know, like what I'm saying is she didn't work the hours, nor was she a doctor or nurse or whatever that would have dealt with Lindsay Clancy. No.
She knew who she was.
She knew who she was because of the trial. So she had watched the trial.
What kind of witness is that?
Right. And that's what I said. At that point, I could come in and, I mean, you're just pulling random people off the street, right? I mean, it'd be like you testifying for Procar or something, you know, like in a trial. Well, you worked there 10 years ago or 11, 15 years ago, whatever it was, right? And then blaming, well, how is it today? Well, you don't know. You know, 15 years ago, it was like this. Right. So that it doesn't add anything. It's more prejudicial to the jury than it is probative. You see what I'm saying? It doesn't add anything. And all it would say is that being more prejudicial, it's going to change the jury's mind of what's today because it doesn't add anything. You see what I'm saying? They're gonna think that's how it's run today, but it's not. McLean sent, this is what our schedule is, this is what we offer, this is what we do, blah, 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 all this stuff. You see what I'm saying? And it's different than what she experienced when she worked there. You see what I'm saying? So that would prejudice the jury and them thinking that's how it is now. So it's not more probative. You know what I mean? So he's not allowing that that testimony from that witness. Which I think was an excellent call.
It was first, we're not doing it else for the rest of your life. He's like, I'm trying to tell you how to skip for.
Right. Or when you worked for the MRDD place.
Right.
Yeah, you can't say how they run it now. You know what I mean? Staff changes, rules change, you know, situations change, laws change, you know? And that was the thing too, is that laws had changed also, and the number of staff. So like when you were working for MRDD, like you have to have so many nurses, so many staff members, blah, 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 per patient, right? So also laws had changed that how many patients they had versus how many psychiatrists, doctors, nurses, blah, 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 on staff at all times. So no different like when you work for MRDD, right? So they cut down the number of patients that they had at the time from when she worked there. So it was just all different.
Yeah, so it's kind of like, well, what did we even add to?
Well, that's what Reddington wanted to bring her in to say that this is how it was when I worked there. Well, it doesn't matter. No matter how it was when you worked there. Be like you saying what a manager does for Speedy. I think it's just, he's throwing so much at the jury. I think it's just to confuse the jury. And that was another thing too, is that he said that Patrick said it was a 5-star, or that it was supposed to be that somebody said it was a 5-star. Stop, Kimball. That somebody said it was a 5-star, psychiatric place. And the judge goes, I don't remember them saying that it was 5-star. They didn't. There's nowhere in the testimony that said it was a 5-star psychiatric treatment. So that's what I'm saying, is he constantly misrepresents the facts and evidence. So today he's supposed to rest, which then they should have rebuttal. So I don't know if they'll have rebuttal this afternoon, and then Friday, and then I'm imagining that Monday it will go to the jury, and with all the evidence, it'll probably be a day or 2, maybe 3. Unless they already have their minds made up. It is 12 women and 6 men. Yeah, 12 women and 6 men on the jury. So, I mean, there's 18, but it's only going to be 12 people, obviously. But, and then they'll draw, I don't know how they do it in Massachusetts. I know in the Commonwealth, I don't know if they'll do it, all the Commonwealth do it the same, but I know like in Karen Reed trial, they did it by drawing numbers, which is now the Commonwealth. But sometimes they have like a bingo ball. Everybody puts their number in, and then the judge pulls it out. The number. Sometimes the defendant gets to pull the numbers. That way it's like there's no bias, you know. But all 18 people are listening to all this evidence, but it's 12 women, 6 men. There were some people that saying there shouldn't be any men on the jury because none of them had ever had a baby.
Then how can you put fucking somebody that's,
Never had a baby.
no. I mean, if you wanna play that kind of shit, then people that are on trial for murder shouldn't be able to judge anybody who hasn't committed murder.
Right.
You've never even committed murder.
Never committed murder yet. You shouldn't be on a jury either. I know. I find that odd. You don't know what it's like to have postpartum. You've never had a baby. And I'm like, I've never had a baby.
Murder's murder, Jack. It don't matter the reason.
Right.
You know, what are you gonna say? Well, I committed murder and I was having a bad day, so you can't judge me. You don't know if I got a bad day.
Right. What you got? What you got? That would be funny if that's what they consider like
Here,
a jury of your peers. Well, you all have to have all have to have psychosis to be on the jury. You all have to have mental problems. You have to be diagnosed with something to be on the jury. What? I know. Or like, wouldn't it be funny if like somebody was getting like charged with schizophrenia? Like, well, this person has, Nick Reiner, you know, he stabbed his parents to death, you know.
right.
We all have to have done drugs before, been to rehab, blah 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 times, and like schizophrenia, all this stuff. You don't know. You've never done it before. Just start pulling people out of prison to like sit on a jury. That'd be wild work. That'd be wild work because could you imagine like a white collar worker or a white collar crime where like you'd have to embezzle like billions of dollars from your company, like because you're a billionaire and you like embezzled like so many, like okay, well Elon Musk and you know like Gates and all, they can only be on the jury. You couldn't find enough people. Well, you only get a jury of 5. Because nobody else knows what it's like to be a billionaire.
Right. Yeah, I mean, you can get really stupid with that.
Right. I know, I thought that was funny when people were writing that. There shouldn't even be a man on the jury. I was like, what? These sidebars take forever. That'd be wild though, because no one would be convicted of anything ever.
Right. That's why they want so many women on that trial.
Because they would be like
they're looking for the
the sympathy of it.
They're looking for other women who have postpartum depression, which is a real thing. Don't get me wrong.
Right.
You know, I'm not saying anything about that, but what I'm saying is it don't give you the right to kill.
Right.
You know, or you're gonna have everybody, pretty soon you're gonna have men saying somehow they have postpartum depression.
Right. Well, like that guy, he just killed his 3 children. For God. A dude just said he killed his 3 children. What was it? Yeah, Ohio father reads the Bible, told his children he loved them, and called his own father, cryptically telling him that his eldest boy would be the hardest one before he murdered his 3 young sons in a horror attack at the family home.
You're gonna go after a bunch of men that killed their kids and say, we're gonna put you on the jury. Because you killed a kid, you know what it's like.
Yeah,
This whole jury of your peers. I mean, there's gotta be some kind of a cutoff to it, because not everybody is your peer.
right,
You know what I'm saying?
right.
You can't have 11 women judge me. Or actually, you shouldn't be able to have anybody that's not a fucking mechanic then if you really wanna. Those aren't my peers. You know,
Right.
people my age. But I ain't the kind of people I hang around with, so I mean, how do we even start calling shit, you know,
Right.
what your peers are? I always thought peers were considered your age range, you know, and shit like that, but if you're gonna start saying that you can't have men in this kind of trial, then you shouldn't be able to have women in a certain kind of trial, and that gets kind of muddy, man.
Right.
I mean, she was really suffering from postpartum psychosis. You know, I can somewhat sympathize with that, you know, but what she was doing, the whole doctor shopping and all that, just don't seem right to me.
Right. So he shot all 3 of his sons. He shot and killed 7-year-old Clayton, 4-year-old Hunter,
Is this the Ohio guy?
yeah, and 3-year-old Chase, Monroe Township, 75 miles from Columbus.
And you know what? This guy's not gonna be able to claim postpartum depression,
No,
you know? Well, I'm sure he'll claim something.
yeah, he said he killed it. He said he killed them for God. He went to church, came home, and killed them, and then sat on his stoop and waited for the police to show up.
We should have showed up with a fucking bullet. They could have done.
Yep, he laid the gun down and waited for the police to show up after he killed him. Was a rifle. But that's what I'm saying. Like, why have we gotten to this place where we're just killing our children? I don't know. Killing our children and our parents. And that's the thing. He's not gonna, yeah, like you said, he's not gonna be able to claim postpartum depression. He's not gonna be able to claim anything. They're not gonna find him psychosis and all that crazy shit. They're just gonna sentence him to prison for 3 first-degree murder charges. You know? Yeah, I wonder how many women will back him like they're backing her. Of course, they're trying to say that Patrick killed him, which, clearly there's video of Patrick not even at the house. He's at 3B picking up food, or he's at the pharmacy picking up medication, all that stuff. Do I believe that he wasn't involved in his life? Yeah. I mean, he's just sketchy to me, but do I believe he killed the kids? No, she killed the kids. And this is what nobody clocks in this whole trial. They keep talking about with her first child, she had a little postpartum. With her second child, she had more postpartum. You would have thought that she would have already been prepared, getting ready, doing everything she could to get, medical help or even psychiatry help, whatever, with her third child. If it was worse with her second, because they keep talking about with her second child, she had even more anxiety, all this stuff, going back to work, blah, 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 that she would have already had those steps. Because even in her diary or whatever she wrote, she talked about having a fourth. I mean, like, holy hell. Like, if you feel like that you want to have a bunch of kids, like everybody said, oh, she wanted to have a big family, she wanted to have more kids, she wrote that she wanted to have more kids, all this stuff. If you feel like you had postpartum with a little bit of postpartum with your first, more with your second, wouldn't you have taken the steps to say, okay, I know I have this issue and I get anxiety, I get all this stuff. Wouldn't you have set up, like, she was a planner? They said, like, she planned everything, like, down to the minute, like 8:36, the kid had to lay down, like, down to the minute. If she was such this planner and had to have everything so neat and organized, wouldn't you have thought that she would have been like, okay, I need to have this also? I mean, I'm just questions, especially when she started noticing it. And then her lawyer even said, well, she wasn't honest because she was afraid she was going to lose her license. She was afraid they were going to take the kids away, blah, blah, blah. Well, if you really, truly wanted help, truly wanted to get the help that you needed, you would have been honest. You would have at least been honest with the people around you. You'd have been at least honest with the people trying to give you medication instead of being on the medication. So they could figure out what you were really going through. And if you checked yourself into a hospital and you really wanted the help, you wouldn't have checked yourself out of the hospital after only 5 days. Or if you did check yourself out of the hospital to go to have your daughter's birthday, you would have then gone back the day after. That's why I don't know. I just have questions and I find it all suspicious. Especially if you're hearing voices and all this stuff like the guy yesterday said, Well, she kept hearing voices. She kept thinking that people could hear her thoughts. They were so loud, blah, 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 all this stuff. Well, then you would have went back. Wouldn't you? I mean,
That's one thing you go back and say, hey, I shouldn't work.
right. You'd have been more honest with your doctors. There was a comment that somebody wrote too on somebody's thing that they just can't fathom that a mother would do this.
Yeah, neither.
I can't, I can't either. But then read the news. She's not the only one who's killing her kids. Read the news every day. Mothers are doing some horrific things.
Well, it goes back to the whole thing. I keep telling you, there's no consequences for anybody's actions anymore.
Right.
That's why you see people going crazy in parking lots and beating people and all that shit. There's just nobody's gonna do anything about it. So why not just do what the hell you want? It's almost turned into like a lawless society.
Right.
A big deal. So you get arrested and you're out and you see a lot of these people get arrested are like, I don't care, I'll be out in 3 hours.
Right.
I mean, they know. They know that there's nothing gonna happen to them.
Right.
The thing is, really, why should they?
Oh my God, this sidebar is retarded. What are we doing here? 52-minute sidebar. Just kidding. But it is like a half-hour sidebar. Oh, knows. They did this yesterday and then just quit.
We're going to be in a short recess, and we're going to bring the jury back in, and we'll call the next witness, okay?
Jesus.
All right.
Oh, she don't look happy about something. We're gonna have a short recess, then we're gonna call the jury back in and have a witness. What? This is the worst trial ever. Does not run smooth at all. Now I see you back there. Now I see you back there. Now I see you. What do you have? I see you. I see you. I see you. I see you. Like, give me my treat. She dropped her bone.
Oh, she'll drop it. She spits it out. She's like,
She's like, give me them other
give me
bones.
the other
Give me them other cookies. I want them now.
good old Lakers. Better help us out of stuff. Terrible teenager.
Your favorite type? Okay.
One more. You gotta wait for a little bit.
She's like, no, give me the whole jar.
I know. I just got another jar yesterday. We've seen it.
There's 2 jars in there. Yeah. No, I sat it down with the other one. On the pantry shelf.
Oiled puppies. Never had oiled propulsion.
I can't wait. One more week. It is Thursday the 20th. Tired yet. It was raining all morning.
Yeah, it's one of those days.
Mm-mm. Yeah.
So,
This court is back in session. Please be seated.
All right. Counsel, we ready for the jury?
Yes, Your Honor.
All right. Bring it.
All rise, please. Hey, all persons having anything to do before the Honorable William Sullivan, Justice of the Superior Court, now sitting in Plymouth, within the Commonwealth. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts, court is now in session. Please be seated.
Yes.
Before the court today, we have a continuation of the jury trial matter Commonwealth versus Lindsay Clancy. Ms. Clancy is present. She is represented by Attorney Kavanagh. The Commonwealth is represented by Assistant District Attorney Jennifer Sprague and Assistant District Attorney Sheila.
All right. Thank you, Madam Clerk. Good morning, everyone. Nice to see you again. I know I just spoke to you probably about 10 minutes ago. But again, I want to ask you those questions, then we'll talk a little bit about what our schedule is today and for the rest of the week. All right, so first question, has any member of the jury read, seen, heard, or overheard anything from any source about any aspect of this case that would affect your ability to be fair and impartial as a juror? Next, is there any other serious matter or concern bearing on your service as a juror that anybody needs to bring to my attention at this time? All right, again, thank you for following those instructions. And then in regards to our schedule today, you're allowed to kind of roll your eyes because I'm going to say we're going to have kind of a short day today. All right. And that is, as I talked to you yesterday about an issue that has nothing to do with any of the attorneys in this case. All right. It's just something we're going to work out and I anticipate it will be worked out so that tomorrow you should count on a lengthier day. All right. I've talked to counsel earlier this morning in regards to where we are in regards to the schedule and the timeline. We are still, if not on schedule, still ahead of schedule. All right. And this delay that we may have a little bit this afternoon won't affect that. All right. So I just kind of wanted to let you know that I appreciate. I know you came in here this morning. It's going to be a short day, but also gear up for a longer day tomorrow. Okay. And so with that, the other thing is I told you it's got nothing to do with any of the attorneys, but it's also or the parties. So you're not to speculate about what this might be. It's also you're not to hold it against either of the parties in regards to this. All right. If you're going to hold it against anybody, you can hold it against me. All right. So with that, we're going to return now to the evidence in this case. And Attorney Reddington.
Thank you.
So we're gonna have one witness end for the day and then have a long day tomorrow? That's what I'm guessing. We shall see.
Good morning. Just thanks, Madam Clerk. Raise your right hand.
So the testimony of the evidence you should give to the court. Sorry, you're not coming between the Commonwealth and the with the whole truth and nothing but the truth. Thank you. You have a seat.
Just watch your step right there.
All right. Well, good morning. All right, I just ask you to speak into that microphone and keep your voice up so the jury can hear you. Attorney Reddington.
Thank you. Good morning. Can you tell us your name and spell your last name, please?
My name is Sheila Kavanagh, Cavanaughh.
And what town do you live in?
I live in the town of Belmont, Massachusetts.
And what are you doing for work now?
I am a board certified chaplain at Brigham and Women's Hospital in Boston.
And I didn't know that there were board certified chaplains. What does that mean?
Well, to become board certified, you need minimally a master's degree in theology or divinity. You need to complete 1,600 hours of training post your master's degree. 1,200 of those hours are occur in a clinical setting, and 400 of those hours are in a classroom setting where we study various disciplines: psychology, sociology, philosophy, theology, and ethics. Beyond that training, we need to acquire 2,000 hours of additional clinical training before we can even apply for board certification. And we have to demonstrate mastery of 30 competencies before we go to a national board, and they make the assessment. I also need an ecclesiastical endorsement, and in my case, that was from the Archdiocese of Boston, from Cardinal Sean O'Malley.
And before you obtained the board certification in your education to allow you to be a chaplain, what did you do for work?
Prior to becoming a chaplain, which is a second career for me, I was a senior vice president at Fidelity Investments in Boston.
And how long were you senior VP at Fidelity?
16 years.
And are you married?
I am.
You have a family?
I do. My husband and I are the parents of 4 adopted children. When I was pursuing my master's degree at Boston College, it was a 3-year master's, but it took me 5 years because we adopted our 4th child while I was in graduate school. She was a 14-year-old girl from Bogota, Colombia.
And how long have you been working now as a chaplain at Brigham and Women's Hospital?
7 years.
In the course of your duties as a chaplain at Brigham and Women's Hospital, did circumstances bring you in contact with Lindsay Clancy?
Yes, they did.
Can you tell the jurors what happened?
I arrived on the morning of Wednesday, January 25th, 2023. I arrived at approximately 8:30 that morning because I was there to relieve the overnight chaplain who was carrying the pager. I was taking over the pager shift, which went from 9 to 1 p.m., although I was working a full day. When I arrived that morning, she said to me, "Did you hear the news?" And
So
Can't say what he said.
so you can't, you got to object, so you can't say what someone told you, okay? That's called hearsay?
okay.
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 So I can say, as a result of the conversation with that person, what happened?
I was summoned to the director of spiritual care's office.
Did you have a conversation with her?
I did.
All right. And as a result of that conversation, what did you do?
I went to Unit 8C in the Tower building of Brigham to meet with Lindsay Clancy.
And what time of day was this?
Roughly between 8:30 and 9:30 that morning.
And when you went in to see Lindsay, what did you observe?
Well, the unit itself was filled with law enforcement officers, both outside the doors of the unit. There was Brigham security, but the unit itself was flooded. There were people from Plymouth County, Boston City Police, Brigham Security. So I had to make my way through concentric circles of law enforcement to even get to the room. I was permitted to see Lindsay, although she could not speak at that time.
And what was her condition that you observed?
She was dressed in medical armor. She had tubes. She was intubated. She had bandages. She had a neck brace. She was just covered and layered in equipment that enabled her to breathe.
I'm showing you Exhibit 121, asking, this may be South Shore, it could be Brigham and Women's, but is this indicative of what she appeared to be when you first saw her?
That looks like it's from South Shore because when, yes.
Does she have the same?
Similar.
Very similar?
Very similar.
Like that?
Yes, very similar.
Did you see her again on another date?
I did. I saw her the next day. Again, she could not speak. She was intubated as well. That was the first week that she was hospitalized.
When was the next time that you saw her?
The next time I saw her was the following week. I have a calendar here of my visits. I saw her on Tuesday, January 31st, and she had been extubated at that point so she could speak.
So the tube had been removed. She was able to communicate, and that was on January 31st?
I believe she was extubated the weekend of the 28th, but I didn't work that weekend, so I saw her on Tuesday, the 31st.
All right. Tell the jurors what you observed and what, if any, conversation you had with Lindsay on the 31st. And let me ask you, how long had it been that they removed the tube?
Perhaps a day or two.
A day or two. Okay. Tell the jurors what she said to you.
She continued to look like the photograph you just saw. She was covered, tubes everywhere, the neck brace. Her emotional state was very neutral, a flat affect. But I remember vividly the first thing she said to me. Now, she had heard me for a couple of days. We had been praying together. And so when I went in on Tuesday, the 31st, she said to me as I held her hand to comfort her, "I am so glad my children are safe."
Was there any other conversation that you had with her?
I replied theologically to Lindsay, and I said, Lindsay, your children are safe. They're safe in heaven with God. And I held her hand throughout that conversation, and we prayed for them.
Did she make any other statements to you?
She did. She alluded to having heard a voice. And the voice, according to Lindsay, told her that if she did not follow the command, neither she nor her children would be safe.
And did she indicate whether it was a male voice, a female voice, loud, soft?
She alluded to the fact that it was a male voice and it was persistent.
It was persistent.
Any further conversation that you recall about that, not about general things, you know?
That came up several times. I visited Lindsay minimally 14 times while she was hospitalized at the Brigham, and the voice conversation came up several times during several of our visits.
Now, after Lindsay was transferred or cleared to go from Brigham and Women's Hospital, did she go to another facility?
She did. She went to Spalding Rehabilitation Hospital.
And do you know when that was?
That was roughly late February, perhaps around the 23rd.
And did you continue to see Lindsay at Spalding Rehab?
I did.
You know when she left Spalding Rehab?
In the late March, early April time frame, perhaps.
Okay. Now, Brigham and Women's Hospital and Spalding Rehab are under the same umbrella of hospitals, is that right?
They are. So Brigham and Women's Hospital and Spalding Rehab are under the Mass General Brigham complex. So for me to visit Lindsay in Spalding, I was still within the same hospital complex, and her psychiatrist at Spalding, as well as the chaplains, advised me to continue.
You can't say what they told you.
Okay.
So when she was discharged from Spalding Rehab, where did she go?
She went to Tewksbury State Hospital.
And fair to say that that would be back around February. It's been a little more than 3 years, 3.5 years.
Yes.
Is that correct? Now, when you saw her in Spalding Rehab and in Brigham and Women's, you were acting in the course of your job. Is that right?
That's correct.
So you're being compensated, you're getting your paycheck and that type of thing.
Yes.
How many times have you seen Lindsay at Tewksbury Hospital?
Perhaps 200 times.
Jesus.
Tell the jury why you continue to see her for 200.
Sustained.
That's speculation.
So can you tell us how often on a weekly basis you would see her at Tewksbury?
Yes. When Lindsay was admitted to Tewksbury State Hospital, I continued to see her on a weekly basis. We had built up a very comfortable, respectful rapport, and I felt it was in her best interest to continue that as she healed. She was still in deep grief. She was suffering.
Sustained.
So
That opinion will be stricken.
Right.
So did she express anything about her children and their loss over that period of 200 times that you saw her thereabouts in Tewksbury?
Objection.
Yeah.
Overruled.
Yes.
Tell the jurors.
Lindsay talks frequently about her children. She loves them deeply. She carries immense grief.
Objection.
That's speculation.
Overruled. Next question.
And has that continued to your observation?
It continues presently.
When was the last time that you saw Lindsay in Tewksbury?
Just prior to the trial starting.
Thank you very much. Appreciate it.
Thank you.
All right, Commonwealth.
This is such a biased opinion.
Excuse me. Good morning.
Good morning.
Oh, I'm so glad she.
You were talking about on January 25th, 2023, when you first saw Lindsay in direct examination, and you said that there were a lot of police officers in the area, correct?
Correct.
But you mentioned that some of them were security personnel from the hospital, correct?
Correct.
And you're aware that the security personnel for the hospital don't work for the state police, the Duxbury Police, or the Plymouth County DA's office, correct?
Correct.
So they're separate and apart from law enforcement, correct?
Yes.
And then are you also aware that on January 25th, 2023, there was a search warrant being executed to collect evidence from the defendant and from the belongings that she had at the hospital?
No, I was not aware of that.
Were you aware that that collection of the search warrant required state police and personnel from the crime lab to be present for the collection of evidence?
I was not aware of that.
Were you aware that following that, at any given time, there were only 2 officers, either Duxbury Police, State Police, or Plymouth County Sheriffs at her room, the defendant's room, at any given time?
I do recall that.
And they were stationed outside of her room, correct, in the hallway?
Yes.
So that the only time you saw this large amount of officers present was on the 25th, when there were security from the hospital and search warrants being executed, correct?
Perhaps.
Perhaps.
Now, you mentioned that
See, this is biased.
on January 31st, 2023, you spoke to the defendant and she told you that she heard a voice telling her that if she did not follow the command, neither she nor her children would be safe, correct?
Correct.
You wrote very detailed notes that are contained in the Brigham and Women's Hospital records regarding your interactions with Lindsay Clancy, didn't you?
Yes, I did.
And in all of these notes that detail every time you interacted with her, you never once wrote that she told you she heard a voice or what that voice said, correct?
Correct.
Why?
And you also said that this voice, talking about the voice, came up in several of your meetings, correct?
Correct.
And you never once wrote about any of it in any of your very detailed notes, correct?
Well, chaplain notes are not verbatim transcripts
So
of
that was-
patient conversations.
Not?
I'm not there to evaluate the patient. I'm there to bear witness to their suffering.
Okay, but the question was, you did not document those statements in your notes, correct?
Correct.
But you did document some other statements in those notes, correct?
Perhaps.
For example, on February 6th, 2023, in a note that you wrote regarding your interaction with the defendant, you said that, or you wrote, Lindsay welcomed the visit and shared her fears of, quote, not being able to walk again, end quote. She continued to express her fears of how her inability to walk may make her vulnerable to others in the future. Do you recall writing that?
Yes.
But you didn't write about her hearing voices?
Do you recall writing on February 9th, 2023, that the defendant was sitting in a chair adjacent to her bed and appeared to be visibly engaged, energized, and hopeful than in previous visits? Do you recall that?
Yes.
You also wrote in that note, Lindsay spoke hopefully of being discharged when the time arrives to Spalding, correct?
Correct.
And then in February 13th, 2023, you wrote in your note that Lindsay also expressed hopefulness in relation to her physical progress. She feels she has gained considerable physical strength and agility despite an inability to move her legs. She admitted that she feels, quote, deserving of this, end quote, in light of recent events.
Wow.
Do you remember writing that?
Yes.
Do you remember on February 16th, 2023, that you wrote in a note that the defendant expressed hopefulness with the news of her anticipated discharge to Spalding and seemed uplifted that she would be cared for in a facility with an excellent reputation?
Yes.
But nothing about her hearing voices.
Do you recall writing on February 16th, 2023, that Paula, the defendant's mother, and Lindsay, the defendant, were playing a card game as they communed quietly, and that Lindsay expressed hopefulness with the news of her anticipated discharge to Spalding and seemed uplifted?
Yes.
And again, you've got all these details about her feelings and her thoughts and what she's doing, but nothing about the voices that you spoke of so many times, correct?
Correct.
And speaking of Spalding, you continued to visit her at Spalding, correct?
Yes.
in those conversations with her at Spalding, did she tell you that how in those first weeks at Spalding, that part of her physical therapy, she was working out with a yellow exercise band?
Wow.
No?
I don't recall her telling me that.
Did she tell you that during that time at Spalding, she reached out to a social worker there and asked for help filling out SSDI paperwork to get an income?
That would be beyond the scope of our conversation.
She didn't tell you those things.
No.
Thank you.
Wow.
Counsel has asked you about her filling out a form for SSDI. Were you aware of what expenses her family were incurring as a result of her physical incapacity, paralysis, and being in the hospital?
From my experience with thousands of patients, I had a very clear idea of the enormous expense.
There's a difference between, as the district attorney very appropriately referred to, that your comments were about her thoughts and her appearance and her feelings. Is that correct?
Correct.
There's a difference, however, between privileged communications with a chaplain and observations of a person's feelings and thoughts, correct?
Correct.
Tell the jury what
No.
effect
You can't play that.
privileged communication has when someone talks to you personally as a chaplain.
They're also
Because I'm not a medically trained clinician, I approach patients in a vortex of trust. Some of our chaplains at the Brigham are ordained clergy. And so there's this understanding that when a patient interacts with a chaplain, the conversations are confidential.
Do you put them in medical records?
No.
The words, like Lindsay indicated that she felt uplifted. I think the counsel read that twice. Were those your notes, or is that what she said to you? Did she say, "I feel uplifted," or is that
That
your
was my
observation?
perception of Lindsay. It was not her words.
Why is it in quotes?
Thank you.
Thank you.
Como?
You said you're not allowed to put the defendant's words in your medical records. Is that correct?
No, that's not correct. It's not that I'm not allowed. It's an understanding, and it's a conversation that's held in confidence with the patient.
Then why are there direct quotes in these medical records from the defendant?
Well, they're not verbatim transcripts.
No, not a transcript of the whole conversation, but you put phrases in quotes. For example, on February 6, 2023, where it says Lindsay welcomed the visit and shared her fears of, quote, not being able to walk again. So those were her words in your note, in quotes, in the medical record, correct?
Yes,
Thank
yes,
you.
I use my best judgment.
Okay. I would move to have these submitted as the next exhibit, the notes of the witness.
So you couldn't
and her
put that
interactions
in
with
her voices?
Ms. Clancy at the Brigham.
And they're a
Any
reporter.
objection? No. All right. They may be admitted.
I have no further questions. Sorry.
Hey, Mr. Reddington, go ahead.
I have no further questions. Thank you.
Okay, thank you.
All right, thank you. You may step down. All right, counsel, can I see it?
That was a bad witness. That witness was so biased. That's sad. I love how he wouldn't even touch that yellow band. One of the cords that she used to strangle her kids with was a yellow band. A yellow exercise band.
I mean, they only come in so many colors. You know, if she's doing some kind of physical therapy, that might be what her weight limit was.
If she was freaked out about killing her kids, talking about them every day, thinking about them every minute of every day, you think that you in a rehab facility are going to, you would deny it. I'm not using that band. You're going to use it anyway? It would bring back memories. It would put you in another psychosis. It would freak you the fuck out. How would you use it?
I told you it was going to be a short day for you, right? And I appreciate your patience with us. So I'm going to excuse you till tomorrow at 9.
Wow.
All right? Same instructions. And that includes reading anything, talking about this case, watching anything. Just don't do it. All right? And when you leave here today, just drive, go home, wherever you're going to go, and plan on being back here tomorrow morning at 9 o'clock. The plan would be that it will be it will be a longer day than today. I appreciate you coming in here today. We moved the case a little bit today, and I appreciate that. So we were able to do that. So I hope everybody has a nice afternoon, good evening. We'll see you tomorrow morning for a longer day. And just remember those instructions from the moment you leave to the moment you come here tomorrow. Okay? Again, thank you so much.
All rise, please. Your executive.
Wow.
Or just people somewhere.
Nope. Yeah.
Chair, to the Courtroom is closed in session. Please be seated.
All right. So what we'll do is we'll take a short break at this point. We'll come back. We'll do kind of a preliminary charge conference. We're going to just, which I know counsel knows, but for everybody else, discuss possible jury instructions, suggestions from counsel. Then we can talk about any logistical issues that we have for tomorrow. And then we'll probably recess at that point. All right. So this will be a short recess and we'll come back up. Thank you.
Order. All rise.
Wow. So he's going to rest. Because they're talking about jury instructions. I'll be right back. Jeez, it feels like they're never gonna come back. They're just gonna call it a day, like they did yesterday. We need that 5 hours later. Somebody said prosecution still has to prove she did it. No, I'm pretty sure she did it.
I ain't question that she did it.
No, not a question at all. They're not even denying that she did it. They're saying,
That's what I'm saying. So why are you gonna come on and say, I didn't even prove she did it?
right,
It's not a question of whether she did it or not.
right, they're just saying whether or not she understood the law as it being wrong. That's what I'm saying. Some of these people, I think, just write shit to write shit. Oh, they're finally moving the camera.
court is
Almost
now in
an
session.
hour break. It was gonna be a short break though.
For the record, we return back to the trial, Commonwealth versus Lindsay Clancy, all parties are present, excluding the 18 jurors.
All right, Counsel, what I kind of wanted to do is at least have a preliminary discussion regarding instructions. And what I would generally do is after we have the discussion is then kind of distribute a draft to council so everybody we could have a more focused charge conference next day or so. But I just kind of wanted to get everybody's thoughts or kind of suggestions that they would be seeking the court to instruct the jury on. So kind of what I'll be using will be the model jury instructions, generally the model jury instructions from the March 2026, the latest suggestions from the SJC. And so Commonwealth, let me kind of hear what your thoughts are, and then I'll hear from the defendant.
So for individual instructions, we have listed opinion testimony, prior inconsistent and prior consistent statements, redactions. I don't think there are too many, but there were some on the death certificates, stipulations, and consciousness of guilt instruction. In terms of what we're looking for for the charges, we'd be looking for an instruction on first and second, with the theories of first being both deliberate premeditation and extreme atrocity and cruelty. In terms of the criminal responsibility instruction, we're asking that the instruction regarding intoxication not be given, because from our perspective, there's been no evidence of intoxication by drugs and or alcohol during the killings. There's testimony, and I think there'll be more testimony about the defendant taking pills after killing the children, and before killing the children, she was on low-dose prescription 10 milligrams of amitriptyline that was recently increased to 20 milligrams, but there's no real evidence of whether or not she actually increased that dose. And then it was a low dose of trazodone and a low dose of, I believe, Valium. So those were prescribed medications that she had reported no side effects from, and I believe in the text with her mother, she said that she was still waiting to actually feel effects from those. So there's no evidence of intoxication from those drugs. And then the only intoxication potentially could be when she took pills after killing the children.
I don't think she did.
And even those amounts from the toxicology are low-level amounts. So we're asking that the instruction on intoxication not be given.
Let me ask you this. I'm going to ask the defendant as well, because I did read through those. And I was trying to find the definition of intoxication as it applies in the homicide instructions. Most of the cases that I was able to find so far is dealing with the OUI statute, Chapter 90, and trying to find the real definition in regards to that. Is it the Commonwealth's position that the intoxication is beyond what was the considered effect of the drugs? Because if you know what I'm saying? So if she takes, if a defendant, I don't mean to personalize it, if a defendant takes prescription drugs and it does create some effect, would that be considered intoxicated for the instruction?
I don't believe so. I think in the instructions it talks about having being intoxicated to the point where it affects your state of mind or ability to control yourself. I think intoxication, especially where there's not a specific definition given in the homicide instructions, I think you go to the general definition of intoxication, which would not just be taking medication as prescribed, but it would be over taking medication or combining with alcohol or other drugs. It's similar to the instructions in OUIs, operating under the influence of alcohol or drugs. I think you would have to go to that definition or to the general definition of intoxication if it's not specifically defined in the instructions. And I think the general definition of intoxication is taking some type of substance, either alcohol, drugs, medication, in excess, and to the point where it's affecting your ability to think and to act and to control your behavior.
All right. All right. Anything? So I've got
I agree.
opinion, prior, consistent, prior, inconsistent, redaction, stipulations, consciousness of guilt, first, second, extreme atrocity, deliberate premeditation, and the criminal responsibilities without the subparagraph or the paragraph regarding intoxication.
Correct.
Okay. All right. Mr. Reddington?
I don't know if the government has been listening to the same evidence in this case. This is clearly an involuntary intoxication defense, at least as far as the judge's charge to the jury, based upon the evidence that's been presented, whether or not it's what we would argue is the over prescription of the medications, whether or not it's the side effects of the medications, whether or not it's the titration or the termination or the immediate cessation of the medications against what normal medical advice would be. All of those factors contribute to the state of mind of Ms. Clancy that was expressed to a lot of people, family members, people that knew her. She had indicated, I think Your Honor knows the evidence, repeatedly indicated that she was affected by the benzos. She was felt that she was being addicted to the benzos, trying to get off the benzos.
2 days.
She indicated that the sertraline was obviously killing her as far as going from 25 to 50 milligrams. And then subsequent to that, when there's additional SSRIs prescribed, to suggest that there's no basis to give the jury the instruction, they may determine based on the evidence that is as a result of the involuntary intoxication from narcotics, not alcohol, obviously, from the prescribed narcotics, not illegal drugs. So from the prescription drugs, that's on all fours with a valid defense that they should be instructed as it relates to involuntary intoxication. I think it's the model jury instructions on criminal responsibility. Obviously, if there's any nuances that I would pick up, I would bring that to the court's attention. But I have tried murder case recently with the model jury instructions, and my memory is that I was pretty satisfied. It was Judge O'Shea, I think, actually in this courtroom a year ago, and I was satisfied with the instructions on lack of criminal responsibility. I would, at some point, ask the court to charge on involuntary manslaughter. I'd ask the court to charge on wanton conduct with a component of the impact of the intoxication. So you can't try this case in a vacuum. You can't present the case to the jury. I know the government would like to present the case only on cruelty and atrocity. They probably don't like the statute that allows a jury to determine the degree of murder, which would be first and second. But I think that the evidence is such that a jury should have the option of considering whether or not we're talking about involuntary manslaughter based upon the evidence that's permitted. So I would defer to the court on the instructions on cruelty and atrocity, premeditated malice of forethought, second degree malice. I would ask the court to consider instructing on involuntary intoxication, to consider on the involuntary manslaughter as a lesser offense, and anything else that I can think of. But right now, that's what.
Anything else I can think of?
Yeah, counsel.
Great, thank you. Commonwealth did request first and second degree instructions. It's our position that involuntary manslaughter wouldn't apply here. The evidence is that there was a specific intent to cause the death. So there's nothing that I can think of in the involuntary instruction that would apply here. Going back to the intoxication just for a moment.
Sure.
All of the medications, most of the medications that defense counsel talked about that the defendant was having reactions to and side effects from were before her hospitalization at McLean Hospital. And she was weaned off of that last one, the Seroquel, that while she was in McLean Hospital. And then she was without those medications and they're out of her system for 3 weeks. and she's just on those other 3 medications. So the intoxication that matters is not what happened in the fall and before McLean, it's what happened on the day of the incident. It's similar if it's an OUI, it doesn't matter if you were drunk in November, it matters if you're drunk on the date of the incident. So what matters here is that January 24th, 2023,
Right.
and those other drugs and the effects that they caused to her aren't relevant to what happened on that day, as they've been out of her system for at least 3 weeks at that point.
All right, so the Commonwealth's position would be that the relevant analysis is what she was taking on or around that January 24th?
Yes.
Okay, all right. All right, any other?
Yes.
Yeah, good, sure.
Occurred to me, again, as I said, it's only fresh in my mind from the case I had here last year. I know the model jury instructions indicate, and I'm trying to find it in here, that there's supposed to be consideration of a chalk for the court to write out the elements of the offense of first-degree murder, cruelty and atrocity, premeditated malice, aforethought, et cetera. And I would ask that you not do that. I don't think that it's appropriate. I think it highlights, if you will, in simplistic terms, premeditated malice, aforethought. I think you and I, we just had a murder case last year on another matter. And I mean, I heard your instructions. You're very forceful with the elements of the offense. And I just don't think we need to have this appendix or whatever you want to call it. And again, I did object to that with the Judge O'Shea. We did not submit the instruction list, cookbook, or whatever you want to call it, to the jury. So I think that the court's instructions would be sufficient. I would not want to have that chalk that is referenced in the model instructions. That's discretionary. It's not obligated. They just say that it might be helpful for the court to give the jury some type of a checklist. But I don't think we should reduce instructions on a murder case to a checklist. And I'm just afraid that what happens is that jurors then take the checklist, as it were, and they kind of look at it or consider it, and they just do exactly that. It's a checklist. So I would ask that you not do that.
All right, just so counsel, my general practice is not to have that kind of list.
Yeah, I remember
I
that, yeah.
generally don't, but I also generally will provide a copy of the instructions to each juror. So they'll have their own full copy and they can follow along, because the 3 of you know they're lengthy and kind of dry. So they'll have those with them. But I'll like I said, I generally don't do that chart. All right, so anything else in regards to the instructions?
No, Your Honor.
Right. So my plan would be to have at least a rough draft available for counsel tomorrow. So you at least have that. And, depending on the timing and where we go in regards to the actual closings, we'll have the opportunity for you to review those, go over the draft, and then any kind of objections or suggestions you want to make, we'll have a chance to do that. But so you'll have, again, it's a rough draft. That's all I could tell you. And nothing's in stone, but at least give you an idea kind of where I'm coming from.
Do you think, logistically, Your Honor, that with the presentation of Dr. Resnick and then the government having their 3 doctors, hopefully we finish the evidence tomorrow, we would be closing Monday?
I would expect either Monday or Tuesday. If the parties may need,
So there you go.
we can talk about that. But, my old experience, there's been a lot of evidence and there's a lot of witnesses. And so if the parties feel that they need like a day to kind of marshal their thoughts, we could talk about that. So either probably Monday or Tuesday. We could talk about that tomorrow. All right. Anything else we need to address, you think?
No, Your Honor.
All right. And so tomorrow we'll be in recess until tomorrow at 9 o'clock. Hopefully we'll start with Dr. Resnick and then, correct?
Yes.
Yeah. All right. You just kind of looked at that. Oh, yeah. So that would be the thought. And then we'll just kind of go from there. If the defendant rests, the Commonwealth can then present their witnesses. And if it's not done by Friday, we go into Monday, and that may mean closings and charge on Tuesday.
Okay.
All right.
And Mr. Verino will be here, yes, to set up the Zoom.
So you're not going to trust me to set that up this time? I think that's a good
Oh,
move.
me.
All right. All right. So thank you, everyone. And so we'll be in recess until tomorrow.
Thank you.
Great. Thank you.
Board, all rise.
So there you have it. Looking to close tomorrow, rebuttal witnesses tomorrow. Probably closings Wednesday or Monday or Tuesday. So, and then it'll go to the jury. They have a ton of stuff to get through. So that will be the end for today. And I will see you at 9 a.m. tomorrow morning. Till next time.
Man, club justice system, but the deck set to fail. You speak for transparency, they call it a crime. Next day, you suspended for 6 months of your time. Pedigree, politics, trophies on the wall. Vanity awards while the ethics take a fall. They say it's for the free, but we know what it is. Power in the clubhouse, silence in the beer. Pedigree, politics, ribbons and lies. Smiles at the banquet, but the truth in disguise. You can muzzle the voice, but the truth don't quit. Dog show, kingdom built on counterfeit grit.